All right, let's get into a story that sounds like a legal riddle. We're going to break down a case where a homeowner went up against his HOA, and in a single dispute, he managed to both win and lose. How on earth is that even possible?
It sounds like a trick question, doesn't it? But this isn't some law school hypothetical. This actually happened, and the answer tells us something really, really important about how these kinds of legal fights are actually won and lost.
So, let's meet the people involved. We've got the homeowner, Rex E. Duffett, and on the other side, the Suntech Patio Homes HOA. Now, Mr. Duffett filed two separate petitions against his HOA at pretty much the same time, and the court just decided to lump them together into one hearing. The result? A perfect split decision.
So let's start with the first petition. It began, like so many of these disputes do, with a simple repair request.
This all seems pretty straightforward, right? Back in July of 2017, Mr. Duffett sees a problem. A crack in the wall. Water's getting into his garage. So he does exactly what you're supposed to do. He contacts the management company and asks them to fix it. He even sent over some photos. And you know, he probably felt pretty confident about his chances. The HOA's own rulebook, their CC&Rs, has a line in it that seems to make this an open and shut case. It says, flat out, the association is responsible for the exterior walls. Case closed, right? Well, not so fast.
So even with that rule in the book, Mr. Duffett lost this claim. And the reason why is a huge lesson for any homeowner. It all boiled down to something called the burden of proof.
Now, in a civil case like this, it's not like what you see on TV. You don't have to prove something beyond a reasonable doubt. You just have to convince the judge that your story is more than 50% likely to be true. You just have to tip the scales, even if it's just a tiny bit, in your favor with solid evidence. And this right here is where the whole thing fell apart. Mr. Duffett had his photos, but they were black and white copies, and apparently they were super unclear. The judge looked at the evidence he was given and, well, literally couldn't see the problem. He said he couldn't even conclude that a crack existed at all, let alone one that needed to be fixed. So here's the big takeaway from part one of our story. Mr. Duffett might have been 100% right about that crack. But in a courtroom, being right just isn't enough. You have to be able to prove you're right with evidence that's clear and convincing. And his just wasn't.
Okay, so that's one loss for Mr. Duffett. But remember, he had filed a second petition at the exact same time. This one had nothing to do with physical cracks or water damage. It was about something much, much simpler. Paperwork.
He just wanted to see the records. Specifically, he asked for the notices and the minutes from any meeting where the board talked about changing the rules or raising fees. You know, this is a pretty standard, fundamental right for a homeowner.
And the timeline here is, well, it's so simple, it's almost painful. December 22nd, he sends the request. The law in Arizona is super specific. The HOA has 10 business days to get back to him. And the management company? They just dropped the ball. They blew right past the deadline.
And not simple failure, that missed deadline is exactly why this second case went in the complete opposite direction of the first one.
You see, unlike a fuzzy photo of a crack, the law here is totally black and white. There's just no room for debate. The HOA tried to argue that their old management company was a mess, and maybe they were, but the law doesn't care. At the end of the day, the responsibility is on the association.
And the judge's conclusion just hammers this home. It's direct, it's factual. The management company failed. They didn't meet the deadline set by the law. It was a simple, provable, procedural violation.
So do you see the massive difference now? For the wall, the proof was a subjective, blurry photograph. For the papers, the proof was an objective, undeniable set of facts. A fax with a timestamp, a calendar, and a legal deadline that was clearly missed. There was nothing to argue about. So let's put it all together. We have two cases, heard in the same hearing by the same judge with the same two parties, but with completely opposite results. So, what's the ultimate lesson here? Here it is, the final scorecard. The first case, about the cracked wall, denied. The reason? Insufficient evidence. The second case, about getting the records, a big win for Mr. Duffett. He was officially named the prevailing party because there was a clear violation. He won and lost at the exact same time. So what are the big takeaways from this whole thing? First, evidence is absolutely everything. Your proof has got to be crystal clear. Second, know the rules inside and out, because sometimes a simple procedural slip-up on their part is way easier to prove than a physical problem. Third, document all your communication. That paper trail is undeniable.
And it all leads back to the most important lesson of all. Being right is not enough. You have to be able to prove you are right.
And that leaves us with one final question to think about. What Mr. Duffett's story shows us is that in the world of legal disputes, sometimes the clearest violation of a simple rule is way more powerful than the most obvious crack in a wall.